to courts. From markets to courts, well, a lawyer has to talk about courts, and that part of it is for any feed suppliers here, or those of you who work with feed suppliers, or who we about all do, Iowa has a contract growers lien, so that those of you who feed pigs for someone else can file a lien with the Iowa a lien statement or a UCC one with the Iowa Secretary of State and get get pretty good protection that you will be paid in front of other secured parties, including the secured lender of the person who owns those pigs. But also we have a lien in Iowa for feed suppliers. It's called the Ag Supply Dealers Lien. And for those suppliers providing feed, they can file a UCC1, a financing statement with the Iowa Secretary of State, and receive priority over the secured lender to the owner of the pigs. But that lien is not real clear as to how it's worded. And an example, I guess a good example, we'll get into the details here. Since we were here a year ago, 5 courts have looked at that one lien, same language, same law. 5 courts looked at it. 3 ruled one way and 2 ruled another. I mean, exact opposites. 3 said the lender wins, that the feed dealer loses, lender wins, and 2 said, no, feed dealer wins. So we'll take a look at that, and we have more cases in the pipeline there, and some that might reach an appeals level court to maybe get some more direction there. And then finally to USDA, and that, of course, I'm talking there about the packers and stockyards issues with disclosures that need to be in the contracts and the proposed rules that we all heard about this summer and fall. And with that, I realized as I walked through that, I have those in the exact opposite order in my presentation. And I didn't plan that, but it worked fairly well. What a segue. Right into the Packers and Stockyards Act requirements here on slide 2. I should say you should all have, and it's available in the back of the room if you don't have them, a hard copy of my slides that you'll be seeing throughout the presentation today. And I've numbered the slides in the lower right-hand corner, so as some of these I'll move through fairly quickly, but if I'll try and refer to slide number when I skip ahead or whatever, so if you're wanting to take notes or circle something or ask me a question later, hopefully with the slide numbers there, that will help stay on track. All right. June 18th, 2008, the United States Congress passed the Farm Bill. Normally the Farm Bill, we all know what's in it. It covers, farm program payments, etc. Well, this Farm Bill had some provisions in it that are very important to livestock producers, particularly swine producers, and that is disclosure requirements and other contracting requirements for those that contract feed for someone else's pigs, and also for those that sell pigs to packers. A lot of poultry provisions in there, but I won't cover those today. I want to start with slide 2. And I guess the main point, we've had several articles in the Iowa Pork Magazine about this, but you can, if you have more detailed questions, those are certainly available. But right now, as we sit here today, GIPSA, the Grain Inspection and Stockyard, I forget what GIPSA stands for, Packers and Stockyards, they are out there now inspecting contracts between owners of pigs, contractors, and contract growers. And just had a producer call me about 10 days ago where Packers and Stockyards Administration had sent him a letter, and in that letter they pointed out what his legal requirements were for his contracts with his growers, and they said they would be in touch with him to get copies of his contracts to see if he's in compliance. Well, let's walk through some of these requirements, and then I'll come back to what the situation is. I just wanted to I've had clients that received the letter. I've had clients who have had Packers and Stockyards Act inspectors come into their offices, ask for copies of the contract, show up unannounced, come in, and again ask for copies. And I've had clients who received calls, one in his combine last fall on his cell phone, and is not exactly sure how they got his cell phone number. But GIPSA is out there, they are doing inspections, and here's what they're looking for. They want to see in any contract that's entered into after June 18th of 2008, and that contract, first of all, there's the date to keep in mind, June 18th of 08. It has to be entered into, altered, amended, revised in some shape. After that date, then you need to, I guess, listen to what I'm going to say. If you have a contract that was entered into before that date and not altered or amended after that date, then the GIPSA requirements I'm going to talk about do not apply. That's number one. What type of contract? It has to be a production contract. That is a contract where one party is placing their pigs with another party in that other party's, gosh, I do sound like a lawyer, don't I? My pigs in your building. You own the building, you're taking care of my pigs, and we have a contract between us. That's a production contract, and that's what they're looking for. Let me give you an example of what they're not looking for and that they have no jurisdiction over here, and that is if I'm putting my pigs in your building, but I'm taking care of them. I'm doing all the work. You're simply, I shouldn't say simply, but you're renting your buildings to me, and I'm putting my pigs in there and I'm taking care of them. That's not a production contract. That's a lease. Now, I work with a lot of producers on these issues, and you hear a lot of producers who are in your shoes, in my example, taking care of my pigs in your buildings. They'll call that a building lease or rental, or I'm getting rent on my building. But no, they're not. They're getting a contract payment because they're taking care of the pigs. That is a very critical distinction, and if GIPSA comes around asking, you need to make sure you know the difference, because they have no right and they don't want to see those contracts where I'm renting my building, or excuse me, you're renting your building to me and I'm putting those pigs in there and I'm taking care of them. That contract is not covered. Here's the contracts we're talking about. Production contracts, first of all, on slide 2, those contracts need to have, after June 18th of 08, if they're entered into after that date, they need to have a right to cancel. At the time they signed it after that date, that contract needs to tell and disclose to that contract grower that you have 3 business days, contract grower, to get a notice of cancellation to me. To me, it's the old vacuum cleaner sales law, door-to-door sales. A lot of states have those kinds of laws where if something was sold to you door-to-door, you have, under consumer protection, you have 3 days to cancel. My personal opinion, it has no place in livestock feeding, but it's the law, and here we are. 3 days to cancel, and the grower needs to have that right disclosed to them in the contract. Number 2, production contracts need to have a disclosure of the additional capital investments. On the first page of the contract, as you can see here on slide 2, on the first page of the contract, it needs to state that additional large capital investments may be required. Now let's stop there a second. That's what the law says, as passed by Congress. Well, when I first read that, I thought, okay, it says you need to have a statement that additional large capital investments may be required. Well, it would seem to me that if additional large capital investments are not required, you shouldn't have to disclose that they may be required, right? Wrong. GIPSA takes the position that because the law said that you have to disclose that additional large capital investments may be required, that disclosure needs to be in the contract. I'll give you an example. I have an individual client I helped write a contract for, and the other party looked at that and said, holy smokes, what'd you slide in that contract on me? What's this large capital investments that you may require of me? I don't remember reading anything about that in the contract. Well, we hadn't put it in the contract, but federal law said we had to disclose it. We had to get everybody calmed down and everything was okay, but I don't blame them. I would have been concerned if I'd have seen that clause. On behalf of the association, we made comments to the Packers and Stockyards Administration that doesn't make much sense to have to give a disclosure of something that may be required when the contract doesn't allow us to require it. So GIPSA has then indicated that if additional large capital investments will not be required, you can disclose that in the contract that additional large capital investments will not be required, but you still need the disclosure. Okay? So, are you with me? All right. Bottom line, you have to have the disclosure. And it either has to say additional large capital investments may be required or additional large capital investments will not be required. Now, your next question to me probably will be, what's an additional large capital investment? As the law was written, there was no definition of what is that. The proposed rules, which will be finalized sometime this year, hopefully it's this year, will define that as $25,000. Any capital investment in excess of $25,000 would qualify as an additional large capital investment that needs to be disclosed. But right now what we're dealing with is simply disclosures that need to be put in the contract. Again, folks, we're just talking about paper disclosure statements. There isn't a whole lot of substance, in my opinion, to this. It's about disclosures that need to be in the contract, and if they're not there, you can be subject to penalties. Several producers who GIPSA has inspected and didn't have these disclosures were fined $1,500, and I've heard of some penalties higher than that, although I've not seen those. So, let me go to the next slide, and then we'll come back to my advice to producers as to how to deal with this. The next slide, slide 3, we're talking about marketing and production contracts. So we're talking about not only the production contracts, but also packer contracts. Okay? Contracts where the producer is selling their hogs to a processor, a packer. There's a requirement in the law about the legal forum, and on slide 3 there, the first bullet point, here's the best way I can explain it as a lawyer. In a contract, you have all seen them where it'll say, if you're other party to this contract, if you're going to sue me, you got to come to my home state, or you've got to come to my home county, wherever that is. Often you'll see that in a contract. That if you're going to bring a lawsuit against me, you got to come to my home turf to do it, not on your home turf. Okay? Well, what the federal law said is the legal forum, under that first bullet point there on slide 3, the legal forum has to be located in the federal judicial district in which the principal part of the production takes place. So, I'll turn the example around. If I'm feeding your pigs and I live in Des Moines, Iowa, and you're from northern Iowa, and you put in that contract that if I want to sue you, I've got to go to northern Iowa to do it, to your home county, you just violated federal law, because I'm feeding your pigs in Des Moines, and Des Moines is in the Southern Federal Judicial District, and you are trying to make me go to the Northern Federal Judicial District in Iowa, and that's a violation of the Packers and Stockyards Act. So, if you're writing the contract as the person who owns the pigs, or the packer who's writing this contract as a marketing contract, any legal forum for any disputes has to be in the judicial district where the principal part of the performance takes place, and in most, I can't think of too many cases where that wouldn't be where the pigs are being raised. Okay? Now, so GIPSA will also look at these contracts to make sure that there's not what we attorneys call a forum selection clause that violates this law. Okay? All right. Next slide, slide 4. If that contract has an arbitration clause, that is, if disputes under the contract, you don't go to court, but you go to arbitration, which is an alternative dispute resolution process. If you have that in the contract, then, as we noted in the first bullet point there on slide 4, any contract requiring arbitration must contain a provision allowing a producer, that is the grower, before entering into the contract, to decline to be bound by arbitration. So if there's an arbitration clause in there, in these contracts that are entered into after June 18th of 2008, there needs to be a clause that allows the grower to opt out. That's what GIPSA will be looking for. Those 4 things that we just talked about. And the last bullet point there, the contract must conspicuously disclose the producer's right to decline. So I guess that means you can't hide it somewhere. It's got to be up. I would suggest it be on the first page, but it doesn't say that in the law. It's got to be conspicuous, to the grower that they have the right to decline it. Now, the proposed rules have some more details here and actually give exact language to use, but again, those are in the proposed rules and they won't become final until sometime this year, later this year. Okay, now on slide 5, we lay out that the USDA was to issue regulations within 2 years on these arbitration provisions, giving us more detail whether there was an undue or unreasonable preference or advantage has occurred in violation of the Packers and Stockyards Act. More rules on what is an additional capital investment, and that's what I talked about. The GIPSA has defined that in the proposed rules as $25,000 or more, and whether the contract feeder has been given a reasonable period of time to remedy a breach. Again, those things are to come out in rules, and those rules are to be out sometime this year. So these are not in effect yet. Slides 2 through 4 that I just talked about, those laws are in effect right now. Here's where we're at today. If you own pigs and have them in someone else's buildings that they're feeding for you, and if that contract was entered into, altered, amended, etc., after June 18th of 2008, you need those 4 things I talked about. On slide 2, you need the disclosure statement about the 3-day right to cancel. You need a disclosure statement about additional large capital investments. You need to make sure that any action is brought in the federal judicial district where the principal part of performance takes place, and if there's an arbitration clause, the producer needs the right to decline. In most of the case, first of all, the first 2 you need in any contract that meets those qualifications. Those last 2 you only have to do if you have that specific contract clause. So, I've received a fair number of calls from producers who have contracts out there who do not meet these requirements after June 18th of 2008. What do you do now? My advice is if you need to get these disclosures placed in the contracts, go to the contract grower, explain the situation, federal law is in place, this is simply federal law, nothing's changing in their contract, and prepare an amendment that has those disclosures. And then have the producer, the grower, sign that amendment, and you will be in compliance with federal law as of today, or the day they sign, I should say. Do not, and I am not suggesting to anyone that you backdate a contract, or if it wasn't in there to begin with, you can't change that now, but you can come into compliance going forward. Have that amendment signed and then have it in your files, and if GIPSA asks for a copy of your contracts, you have that. And show it to them just that way. That here's the way it was. I became aware of the requirement, and I then had the contract grower sign it, and I'm in compliance now. And in most of the cases I've seen, I think you'll be okay with GIPSA. Again, we have to be upfront with them that it wasn't there to begin with, but you understand the requirements now, and there it is. Now, notice that one of the requirements is, of course, I'll go back to slide 2. One of the requirements is when you hand that grower the amendment that says they have 3 days to cancel, that better be a very real option to them that they would have 3 days to cancel. Now, my experience over the last few years, most contract growers are very pleased to have the contract that they have, given the situation most pork producers are in with the markets, etc., and contracting opportunities may not be the best out there now, so I haven't heard from any producers who've had a problem with growers who want to cancel. But if you're the one who owns the pigs who is presenting this contract for an amendment, you need to be aware that that right to cancel has to be a real and exercisable right by that grower. If that, otherwise, go forward with that amendment, have it signed, and then you're in compliance, at least as of this point going forward. And for sure, any contracts that are new contracts going forward, or renewals, amendments that you have the grower sign, you must have those disclosures in there. Okay? The question was, what is the definition of a capital investment? I talked about the threshold, but what is it? Is it just what you... I'll say it this way, and I think most everybody here heard you, but the way I would say it and I've been asked this question, is it what we would all consider to be a capital investment, something that goes towards the building, as you said, or does it include other things such as interest or, oh my gosh, maybe even legal fees or something like that? And the answer is the law doesn't define it, but the proposed rules do, and the proposed rules take a very broad view of what is a capital investment. They include, in the proposed rules, they include what I would consider operating expenses, interest, consultant fees, and I don't think that's the proper definition, and most the comments I've seen on the proposed rules that I've worked with people on have encouraged USDA to tighten that definition down to what would be a true capital investment. Because I think the term capital investment by itself would be the first part of your question, expenses that go towards building upkeep and that sort of thing, and it should exclude repairs too. But right now the proposed rule would be very broad and would include things that I wouldn't consider a capital investment. The only thing I can say right now is I think in deciding whether to put the disclosure in or not, I think to be safe, you just have to put the disclosure in. If there's any question about whether you'll trigger the capital investment, you should just assume that you do and tell the producer they may be required to make an additional large capital investment, and hopefully the grower understands that you're making that disclosure as required by federal law. Okay? Any other questions? All right. Now I'd like to move on we'll go to slide 6. We're heading into the second part of the title, and that is we're getting to the court issue, but we're not there yet. I want to talk about liens. The first lien, and these are liens under Iowa law that protect a person's right to getting paid. You always have the right, when you enter into a contract with someone else, you always have the right to get paid from that someone, but liens, what they do for you, as most of us know, liens give you some priority, because usually when it comes down to someone not paying you, it's often because they can't, because they're not financially able, and if they're not financially able to pay you, there's somebody else who's not getting paid either, and the question is, between you and that somebody else who's not getting paid, who wins? That's what a lien does. A lien puts you in front of that somebody else, which is usually a financer, as to who's going to get paid or not. Landlord's liens, not directly applicable to the topic today about contract growers and feed dealer liens, but Iowa law has a landlord's lien for farmland or livestock facility owners. So if you own buildings, renting them out, in that example I gave where it's not a production contract, then you need to take a look at the landlord's lien. Okay, slide 7, talk about some of the details on a landlord's lien. I'll let you read those. Slide 8, here's the production contract lien for either livestock or crops, but we're primarily interested, of course, in livestock. If you're feeding hogs for someone else in your buildings, you have the right under Iowa law that within 45 days after each group of pigs is delivered to your buildings, or within 180 days, and I'll cut some language out here, if it's a nursery, because finishing buildings would not qualify here. There's monthly or more frequent deliveries. The 180 days, where you have 180 days after delivery to get your lien filed, is only applicable, as I've seen in the hog finishing business, to nurseries, and even then, not all nurseries. It has to be monthly or more frequent deliveries, and then you have 180 days. The most normal situation is the within 45 days, that first bullet point. So if you've got a wean-to-finish building that you're feeding someone else's hogs in, and you want to make sure that you have priority to payment within 45 days, you file a UCC. After the pigs, each group comes to your buildings, file a UCC one with the Secretary of State. We'll talk a little bit more about that in a second, but the bottom bullet point there, I've had several questions over the last year or two since we've had all the financial issues and market issues in pork production, that, okay, I feed for someone who has multiple sites, so they would have continuous arrival, as it's called in the law, or monthly or more frequent deliveries at all these sites. They would qualify there. But no, you don't look at all of the sites owned by that person. You look only at your individual site as to whether there's monthly or more frequent deliveries, as to whether you get 45 days or 180 days. And you might suspect, usually when this question comes up, is when someone has missed the 45-day deadline but is still within the 180 days. They're looking for a way to still get their lien filed and have priority. But you look at it site by site. Okay, slide 9. You may file after the deadline dates, but you won't have first priority over a previously filed UCC1 here. Here's what we're talking about. You're feeding pigs for somebody else, and that somebody else has a bank who has filed a lien, a UCC1 on those pigs. If it comes down to who gets paid, if there are financial issues there, what you're trying to do is file within 45 days so that you get paid for the work you've done to take care of those pigs. And if there's not enough money to go around, you would have priority over the producer, the owner of the pig's financer. Okay? Now, sometimes when I give this talk, I get questions. Well, how do banks feel about this lien getting filed? And you can imagine the bank who's loaned money on the pigs may not be overly enthused to see a lien in front of them. But I've given this talk to bankers, and for every bank there is out there, or financial institution that has loaned money on pigs, there's another financial institution who has loaned money to the person who owns the building. And the financial institution who loaned money on the producer who owns the building is very pleased that that producer has filed a contract grower's lien. So my point here is, in any situation like this, which is unfortunate when there's financial trouble, but there's always winners and losers, and there's usually a financial institution behind the winner and behind the loser. I realize, sometimes this is a controversial issue with the lenders who have lent money on the livestock, but we also have the situation to make sure the contract grower is protected, and their lenders are very interested in them being protected. So as in any issue like this, there's, as I said, there's people on both sides of it. The goal here is to tell growers what options they have available. The other situation I've run into in working with this law over the last few years is that the owner of the pigs often, at first may look at it, well, I'm not sure I want my growers filing liens because that shows up as a lien against me. But what happens when there are financial problems that occur, the owner of the pigs, the producer, often feels a very strong commitment to the contract growers and really wants to see those contract growers get paid for the work they've done. So again, I know there can always be controversy here, but I think one needs to stop and look at all sides of this issue. That's why this law was put in place, is to provide some protection to contract growers who have invested a substantial amount of money in those buildings. Okay. I can't think of any more issues unless you have any questions about how that lien works. We see quite a few of these filed now over the last few years, and I'll leave it at any individual. Often one of the worst phone calls I can get is when there are financial issues for the owner of the pigs. The contract grower is now maybe a month late in getting paid, maybe 2 months late, and calls and says, well, I didn't get it filed within the 45 days. And many contract growers look at this, well, I only want to file it if I think there's a problem. Well, I guess my response to that is, and that's up to you and the parties involved, obviously, but do banks wait till they think there's a problem before they file their UCC1? No. They do it as a matter of business. It's just a course of business. It's not that they don't believe they won't get paid. They're just protecting themselves. And I think contract growers should consider it the same way. It's a matter of business. It's not that you don't trust the other side. You're just taking those steps necessary to protect you, your family, and your commitment to your lender. Okay. Okay. The question was, can you hold those pigs hostage if you're the grower and haven't been paid when it's time for them to go to town and your UCC is filed? you have rights under the law to enforce your contract grower's lien if you filed it. And as you've said, holding them hostage, in other words, saying they're not going anywhere until I get paid, that is, I would consider one of the extreme remedies. The remedy I see used most, and that I would encourage people to use under the law, is to contact the packer where those pigs are going and provide the packer with a copy of your UCC-1 that shows that you have a lien filed, and request that the packer place your name on the check for those proceeds. That's the better course of action, because one, holding the pigs hostage, I think, exposes you to some potential liability for, number one, maybe that producer that owns the pigs has a contract they need to fulfill. You could cause them to violate the terms of their contract. Issues about death loss if you hold on to them too long, pigs getting too heavy, feed, etc. I don't encourage that. I encourage the approach of contacting the packer and having your name placed on the check. Okay? And I'm glad you brought that up. That is the step to enforce that we see. And now you got to be careful when you do that as a grower. You need to make sure that packer understands that these are the pigs coming from my place, put my name on the check from the pigs from my place, and I don't want my name placed on a check that pigs come from other places, because then you're tying up proceeds that are not yours. Now you might say, how do I know that? That's where it gets a little tough. And you just need to take steps because pork production is a fairly small number of people relatively, and you want to stay in business for a long time being a contract grower, and you have the right to exercise this lien, but you need to do it you need to do it legally, and you don't want to be tying up funds that are not yours. But if you have to err on the side of tying up too little, or if you don't know for sure, then go ahead and get your name on those checks and then get it sorted out as soon as you can. And then once you know that that check that your name is on is not for your pigs, get it released as soon as you can. The other situation is, the question I often get is, okay, I don't have my lien in place, but by gosh, those pigs aren't going anywhere until I get paid. You can do that, and that's called an adjuster's lien under common law, and you do have a lien for taking care of those pigs without having filed it. But the problem is that lien is, in Iowa anyway, is not superior to the bank's. You're in second place. So you got to be careful. You're kind of playing poker there, and you don't have all the cards in your hand that you need. But by and large, I've found that many lenders are pretty good to work with in that they want their collateral taken care of. What I would advise you to do, if payment is becoming an issue, is, and we'll talk about a little later, communication between the parties is key. And if you have the opportunity to be in communication with the lender for the pork producer, just make sure they understand you want to continue to take care of the pigs, you want to do your job, but you need to be paid for doing that job. And by and large, I've, not always, but many times you'll find that you can get something worked out to assure that you will get paid. I slipped in a slide here, slide number 10. I can't give a talk about contract growing, feeding pigs for someone else, contract feeding pigs, without giving my standard warning. If you're doing this, it has nothing to do with liens here, but please check on your insurance. Because if someone else's pigs are in your buildings, you need to make sure you have insurance in case something happens to those pigs that could be attributed to you, where you would be found to be responsible. You don't always have insurance for that. And I talked about some of the worst phone calls I get. One is when they don't have the lien in place and they're not getting paid. Another call I hate to get is when a contract grower calls and says, just had a terrible thing happen, building a pig's suffocated, and it appears it might be my fault, and I won't go into what reasons those could be, and I called my insurance agent and I don't have coverage. He or she mentioned something about care, custody, and control exclusion. I won't go into details on that, but check your policy. If you're contract feeding, go over it with your insurance agent, make sure they know you're contract feeding, and make sure if you want coverage, make sure you have it. Okay. Slide 11. Now we're into that area of courts that I talked about in the title. This is the ag supply dealer's lien in Iowa. Covers feed, seed, chemicals, fertilizer. It also applies that it gives you a lien on livestock and crops. These are for feed dealers. They must file within 31 days of the purchase. So if they, again, may file after those deadlines, but don't get priority then. Slide 12. The lien on the livestock feed has priority over an earlier perfected lien or security interest, but that second bullet point says, and this is where the feed supply dealer's lien is so much different. There's a requirement in some people's minds. This is where the 3 courts on one side and 2 on the other come in. The Iowa law has a clause about sending a certified letter. If I'm a feed dealer and I'm providing feed and on open account and I file my UCC1, there's a provision in the law that says you must send a certified letter to the lender letting them know that you're going to do that and requesting the financial status of the person you're selling feed to. I won't go into all the details of how that letter works and what has to be in the letter for this discussion, but there's a real question under the law whether you have to send the letter or not. And some feed dealers have sent the letter. They get the response back from the lender that, yes, there's enough equity there. Go ahead and provide feed. If you do that, then there's no question you have priority. If you don't send the letter as a feed dealer to the lender, then there is a question about priority, and that's where the 3 versus 2 comes in on the courts. And I will, as I note in the last bullet point there, the safest course of action is to send the letter. Slide 13 is some more general information. Here we go, slide 14. So I've kind of laid out the issue. We've had quite a few court cases filed on this and 5 that the courts have ruled on. And this is all about whether the letter had to be sent that I just talked about. All of them filed their UCC1, but all of these cases were about not those feed dealers who didn't send the certified letter. And again, there's a real question in the law about whether you have to. So these feed dealers made the decision that they weren't going to, that they felt they had priority without doing it. Well, these first 3 courts, one is a bankruptcy court in Iowa, and the second bullet point is a bankruptcy court in North Carolina dealing with an Iowa feed dealer. The pork producer was from North Carolina. And then the third one is an Iowa district court, Ida County District Court. These 3 courts looked at the law and said, you have to send the letter, no priority without doing it. Okay? So the feed dealer lost here. Go to the next slide, slide 15. These courts looked at the same law, same set of circumstances, no difference. They didn't send the letter, and these courts said, no, you don't have to send the letter. That the law, and in fairness to the courts here, the only court decision I strongly disagree with here is back on slide 14. The first court decision there in the case called N. Ray Crooked Creek Corporation, and I'll not make any comments about the name of that choice of name there, but this court here said, this bankruptcy court said, the law is clear. You have to send the letter. I would strongly disagree with this court because the law is not clear. Otherwise, we wouldn't have 3 courts over here and 2 courts over here. The law is not clear, and all the other courts said it's ambiguous. What you have here, laws, people who write laws do their best to make them clear, but sometimes in the process of negotiation and getting a law passed, it gets written so that it's not clear. And what we have here is one clause in the law says you have to send the letter, and you go back here and about 3 sections later, and it says, as these courts found, that for feed, the letter is not required. Now, it doesn't say it near as clear as I just said it, or else we wouldn't be talking about court decisions. But that's where we stand. So, if you're a feed dealer, working with a feed dealer, I would go back to the safest course of action is to send the letter, but there are, I think, some very good reasons why not to send the letter, and because I think it raises a whole bunch of other issues. But right now I can't tell you what the law is because the courts can't agree, and I certainly can't do any better than the courts right now. So that's where it stands for feed dealers in Iowa. Any questions on the egg supply dealer lien? Slide 16 is the Iowa Veterinarians lien. I will leave that for your reading. Also on liens, we have how about a lien for the owner of the pigs? Here's a situation in a 2004 South Dakota case. This has nothing to do with pigs, but it illustrates a situation, and it's not an Iowa case, but luckily we don't have to have an Iowa case yet. There was a company in Minnesota that owned cows and put them out for lease or a contract with a farmer in South Dakota. Farmer in South Dakota turned out to be not the most honorable individual maybe, and that farmer in South Dakota, who also operated a sale barn, decided to pledge those cows as collateral to their bank, even though that farmer in South Dakota did not own the cows, but pledged them as collateral as their own. Okay, whole deal goes south. What you might suspect then happened is company in Minnesota says, well, those are our cows. We didn't need to file a UCC1. We owned them. Bank in, I think they were in South Dakota, says, hold it. Those were pledged to us as collateral. They stated that they were their collateral, and we filed a UCC1. Court in South Dakota says, company in Minnesota, you lose because you should have filed what we call a protective filing. You could have filed in South Dakota and said, yeah, those are our cows, and we're putting you on notice with a UCC1 that, again, is called a protective filing, letting everybody know through that filing that those are our cows. They didn't do it. They lost. So, if you own livestock that you're putting out with anyone else to be taken care of, to be fed, etc., if you want to be absolutely sure that you're safe there, that you're not dealing with someone who would do something like pledging them as collateral to somebody else, you can file a UCC1 statement. It's not really a lien, it's a protective filing, putting everyone on notice that that is your property. Okay. Slide 18, I think, is very important when we talk about liens. If you're going to file liens, you have an obligation to terminate them when everything is taken care of. And what Iowa law says is you must terminate by filing a termination statement within 20 days after written notification from the other party named in the lien if they've done everything they're supposed to. Well, what that means, though, is those liens can lay out there a long time, and sometimes the owner of the pigs doesn't notify you to have it terminated. So it can lay out there, and what sometimes happens when the owner of those pigs goes to refinance or something, those liens show up through a lien search, and then you get the call to terminate. I think the best course of action for contract growers to do is once you're paid as you're supposed to be paid, if you filed the lien, don't wait to be notified. Go ahead and terminate it. That shows that you're serious about being a good business person and doing what's right in filing that lien and going ahead and terminating it. Then when you get the next group of pigs in, and probably you'll get the next group shortly after you, if it's weaned to finish or whatever, go ahead and file your next lien, but terminate the lien once you've been paid. Again, that cleans up the record, and I think it's just a good policy to do even before you're formally notified. That's by the other party. Okay, I'm going to skip over 19. This is about if you're buying products and to make sure that you don't put money down and then lose out, or if you're selling. This is the slide on sellers. If you're selling pigs or something else, and you want to protect your right to payment. Slide 20. You have some options. I mean, most people would say, if I sell something to someone and I don't get paid, why then, hey, those are still my pigs, because maybe my contract says title doesn't pass until I get paid. That may be true between you and the buyer, but buyer has a secured lender behind them, and the law is clear that the secured lender of the buyer is in front of you, even though the buyer didn't pay you as the seller. They step in front of you, and that secured lender gets superior rights to those pigs versus you. Doesn't sound right, but that's the way it works. So if you're selling pigs, whatever it is, you have some options. You can take what's called a purchase money security interest there in the second bullet point first bullet point, get a subordination agreement, or the last line there, last bullet point, I've worked with a fair number of SAL units in drafting contracts, and probably the best way to do it is to get a letter of credit from the buyer's lender, and that is an irrevocable letter of credit that states they will cover, if the buyer doesn't pay, they will cover those. And letters of credit are used in the commercial world fairly often, not a whole lot in agriculture, but becoming more and more common. If you're selling anything including pigs, I'd sure take a look at that. Okay. Now, we've covered the lien issues. Now we're into the market side of things that I talked about first, and that is, what are we going to do between the parties to these contracts if we get into a situation where one party is suffering financial problems, and how do you work your way through problems? Well, first of all, let's talk about when you enter into a contract. In this slide 21, many would consider, maybe contracting 101, or this is pretty basic. Don't need a lawyer to tell me these things, but in all the cases I work on with people who are having contract disputes, a lot of it comes back to what's on this slide and pretty basic principles similar to this. One, read and understand it before you sign it. And I know that seems basic, but you don't know how many times I get into a contract dispute and my client will say, well, here's what I had to do, I did it, and now they're telling me I'm in default. I say, well, fax me the contract, I'll take a look. I read the contract and it says something different than what the client just told me. And the client was told something different than what was in the contract. When it comes down to push and shove, it's what's in the contract. So read and understand it before you sign it. Often I'll have people say, and they'll get a contract to me to review it, or any other attorney, and that's good. Have someone review it, but the key is, I can understand it, I can explain to you what the problems are, what the good things are, but when it all comes down to it, you need to understand it just as well or better than I do. Maybe not on the legal issues, but on the day-to-day workings of that contract, you need to understand it, and you need to spend some time with it just as much or more than I do. Know what is required of you, know the other party's financial and other business history. Bullet points 4 and 5 there. If it is in the contract, you must do it. If it isn't in the contract, it isn't part of the agreement. And again, it comes back to knowing what's in the contract. And if you're told something different, if there's something in there that says you have to do it, and you're told by someone verbally, no, you don't have to do that, then tell them, okay, that's great, but let's put that in the contract that I don't have to do it. Get it in writing, because when a problem happens down the road, it all comes back to the written agreement. Yeah, you can try and prove what was said verbally, but that just means a lot of lawyer arguments, and lawyer arguments cost money. Let's get it right the first time if you can. If it isn't in the contract, it isn't part of the agreement, same concept there. Any amendments to the contract must be in writing and attached to the contract. Slide 22. Oral agreements are binding in most cases, but they're more difficult to prove and hard to remember what you agreed to. Written agreements most often have a provision which states that the written agreement supersedes all previous oral agreements. Most often have a provision which states that any changes must be in writing. On to slide 23. Kind of back to some basics here. Everything is negotiable, including whether to sign the contract. Now, maybe in some cases that I'm being naive there in saying that, but when that contract is laying in front of you, and if there are provisions in there that you don't like, yes, it's your option to sign it or not. After you sign it, you've lost those options. Now, sometimes I'll give a client advice, well, I think that's a bad clause there, but ultimately the decision is up to you, the person signing it. If you don't like the clause, but if it's not a deal killer, obviously then you need to understand what the problem is with it, what can you do to deal with it, but know that it's there and you're going to have to deal with it, or else don't sign the contract. Discussion, communication, I think is the key in the second bullet point. I've talked about having it reviewed, but again, make sure that you understand it. Even if the other party will not change a term, at least you know their interpretation, and make it clear there is no contract until everything is in writing and signed by all parties during the negotiation process. Again, you don't want any misunderstanding about whether you have a deal or not. Slide 24, communicate with the other party. Now we're moving into the area of when there's a default, when things haven't went well. My advice is, if you're having trouble performing your part of the contract, things aren't going well, you're having financial problems or whatever, get a hold of the other side and let them know right away. Some would say that's not a good idea. You're probably just setting yourself up for them to take action quicker. But I think all in all, in the end, the best thing to do is early communication. And I know a lot of us went through the problems 2 years ago with that pig owners were having, and they went to many people and said, would you accept a lower price? You have a binding contract to feed my pigs, but would you accept a lower price for 6 months or whatever while I kind of work out of this market situation? And they didn't have under most contracts, they don't have the right to do that unless you agree to it. Most contracts don't have a clause where they can come to you and make you take a lower price. But I know a lot of contract growers who agreed to do that, took a lower price, and the thing to do is, one, get it in writing. Get that contract amendment in writing if you are going to take a lower price. And two, maybe try and negotiate a deal where after things get better for the other side, maybe you know, let's have a little give and take here. When things get better and you're making good money again, maybe you can then pay some of that back. I'll help you through the tough times, but will you help me then when things get better for you? Again, negotiation. All right, slide 25. One of the questions I get, and I'm going to get it again, as will many people, with $6 corn, is that an impossibility? Does that mean I don't have to perform my contract if I have it with a packer or whoever I have it with? If I can't afford to feed pigs at $6 corn, is that a force majeure, and can I get out of my contract because of it? I've got question marks there, and I think I'll say the last bullet point, the best way to say it now is economically burdensome conditions do not usually qualify as a force majeure event that lets you out of a contract. Most courts, and I've researched this a lot 2 years ago when we ran into the market, and I shouldn't say 2 years ago, last summer, and we may be looking at it again, but in most cases, the high price of feed inputs, bad market, poor market conditions, etc., do not qualify to get you out of a contract. But is there a line there? $6 corn may not be. What if, and I hope this never happens, but if we have a drought next summer, and if some people are telling us it could be $10 corn, yeah, I might reserve to take another look at that then, because it's all. I mean, does anybody contemplate $10 corn? No, we've not. When you entered into that contract, nobody contemplated that. And could that be considered an impossibility to feed pigs under your contract? If you're the one paying for the feed and selling pigs for a set price or something like that, could it be considered a commercial impossibility? Then, the higher it goes, the better argument you have. How's that for a lawyer answer at 3:30 on a Thursday afternoon, second day of Pork Congress? But again, and seriously, it is. There are not any bright line, easy answers to some of this, but I can tell you the conditions we saw a year ago with market conditions and 2 years ago with the high corn price. I'm not aware of any court at that juncture saying that those qualified as force majeure clauses or impossibility of performance. Slide 26. Now we're getting into what's called demand for adequate assurance of performance and all that. And given the fact that I'm almost out of time, unless anybody has any questions on that, I'll move to the next slide. I want to point out on slide 27, mediation, the third bullet point down. If you're having a dispute under your contract growing arrangement, if you're feeding pigs for someone else or if your pigs are being fed by someone else, if there's a dispute there, Iowa law requires that you go to mediation before anyone goes to court. So I think this is a very helpful clause, section in Iowa law, a very helpful requirement, and gets the people to sit down and try and talk it through before they decide to duke it out. It's really helped settle some of these cases and avoid going to court. Okay. I think slide 28, I'm talking about pig purchase agreements there and what are the damages on default. I'll leave those to your reading if that's okay. Slide 29 is termination of contract and how a court might figure damages and what you'd look at and when a party can terminate. I think let's just leave it here. Many times I'll get a call from someone that says, well, they missed a payment. And I just want to I'm done. If they miss a payment, I'm out of here. I've got other people that will feed my pigs. Don't be too quick to pull the plug because then you could be the one that's in default. Most courts they allow, and we talk about it here on this slide, slide 29, that default must be total and a material default, and a lot of that type language. Bottom line is missing here I have it on slide 30. In general, under a pig purchase agreement, a buyer's failure to pay for one group of pigs in a multi-group contract is not sufficient legal basis for a seller to terminate the contract. Doesn't mean they don't owe you for what they didn't pay you, but terminating a contract is much different than telling a court, hey, they owe me money for what they didn't pay me, versus terminating the contract. You need to keep those in mind because I've seen people get in trouble for thinking they could walk away or terminate a contract because the other side didn't do something when in fact a court would say that wasn't enough to terminate.